Good morning, and thank you for joining us for a Tax Practitioners Board webinar. My name is Anna Miliauskas, and I'll be hosting today's session. We've created this webinar to connect directly with you. We value your opinion, and today's an opportunity to raise any questions you have directly with us. To begin, I'd like to share some housekeeping tips so you get the most out of the session. First of all, you'll notice a range of icons on the top right corner of your screen. To ask a question or interact with other attendees, simply click the purple chat icon. Feel free to send through your questions and comments throughout the presentation, and we'll respond to you as we go. Just a note here that questions are visible to other attendees. So if you have a question that's private in nature, please contact us via our online inquiry form at tpb.gov.au/contact. If we're unable to answer your questions today, we'll respond to you out of session. If you're experiencing any technical difficulties, please call Redback Support on the number listed in the Help section of the top right menu, which is 1-800-733-416. Following the webinar, we'll provide a copy of today's presentation slides and some helpful links. We'll send these to you via the email address that you used to register for today's session. You can also access them by visiting the Webinar Resources Hub at tpb.gov.au/webinar-hub. I'd also like to remind you that today's webinar will count towards your continuing professional education, and you can claim 45 minutes for attending. However, we do not issue attendance certificates. In today's presentation, we'll help you understand your obligations when using and disclosing tax file numbers, or TFNs, in email communications. In particular, we'll look at the relevant legislative frameworks that protect TFNs and TFN information, the obligations of tax practitioners when using or disclosing client TFNs in email, practical steps to consider, and the possible consequences for failing to comply with the Code of Professional Conduct. To finish, we'll answer some of the common questions we received during the webinar, so make sure you submit your questions via the chat box. Before we begin, I'd like to introduce our speaker for today, Greg Lewis. Greg is a tax advisor and board member at the Tax Practitioners Board. He began his career as a graduate at KPMG, then moved to Ernst & Young, where he was promoted to the position of principal in the tax division. After returning to KPMG as a partner, Greg went on to become a consultant in tax at the law firm Minter Ellison. He has been a company director, chairman, committee member of various organizations, both public and private. He is a consultant to private companies on a wide range of technical and strategic matters. Greg holds a Bachelor of Economics and a Master's in Taxation. He was appointed to the board in December 2015 and reappointed in February 2019. Greg served as acting chair of the board for periods in 2016, 17, and 19. Thanks for joining us today, Greg, and I'll hand over to you now to start the presentation.
Thanks, Anna. It's fantastic to be here on a warm Thursday morning in Melbourne I'm presenting from. So for all of you in Melbourne, I hope you're enjoying the cold weather. But first off, can I trust that everybody on the call today is safe and well, and that all of your families are safe and well given these unprecedented times we're living within. Just to start off with today, we've got a couple of important people that are going to assist us today. We're calling them chat assistants online. One is Fiona Stritt. Fiona should be well known to many people. Fiona joins us on many occasions. Fiona is one of the TPB's policy and legislative advisors, so she'll be helping assisting myself in answering your online questions. And also our TPB Communications Manager, Julie Shaw. Welcome to both of the ladies here today. So please, can you punch through your questions as we go? I suspect today we're going to get a lot of questions. This is a topic that I can say in my last webinar I undertook with the Director of the Office of the Australian Information Commissioner. We had a number of questions, so please put your questions in writing. I think it'll be a great conversation today. Just by way of background, some of the recent stats I just wanted to set the scene off with from the Office of the Australian Information Commissioner show, I suppose, a variety of risks involved when using email for transmission of personal information, which can include TFN information, which we're going to talk about today. The OAIC Notifiable Data Breaches report for the period July to December 2020 reported that 18% of data breaches involved tax file numbers. So that's interesting. I wasn't aware of that percentage being that high. 38% of data breaches actually occurred due to human error. Common examples of human error breaches including sending personal information to the wrong recipient via email. You might type in Greg instead of going to Greg Lewis. It might go to Greg Fred or someone else. And that represents 45% of human error breaches. And there's also the unintended release or publication of personal information, which represented 16% of human error breaches. So that's some interesting information to get us started for today. The other last comment I'd like to make here is that the top 5 industry sectors for human error included accounting and management services, which is clearly within our industry, and which highlights, I think, today the importance of what we're talking about, not just from a regulatory perspective, and I'll talk about the frameworks around it from regulation, but more importantly, what does it mean for your business and your reputation through inadvertent disclosure. Just on a little bit of a marketing pitch for the board, just like to note, we've actually recently released a practice note that delves deeper into the use and disclosure of client TFNs in emails. And I will ask Anna, if you don't mind, Anna, at the end of the webinar today to send out that link. So I would highly encourage everybody today to delve into that practice note. Let's start off with legislative frameworks, as I spoke about. It's really a good segue into setting the scene from a statutory perspective. So TFNs and TFN information are protected by what I'm going to term the following, but it's not a fully exhaustive list of legislative frameworks, but these are the key ones that we're going to talk about today. So you've got obligations under the Privacy Act, in particular the Tax File Number Rule 2015. And throughout the webinar today, I'm going to talk about that as the TFN rule, just for short. We've also got obligations under the Privacy Act, 1988, Commonwealth, or in short, I'm just going to talk about it today as the Privacy Act. And then also we've got the Australian Privacy Principles, APPs for short. These include, and most of you should be aware of this when I've spoken on webinars, the Notifiable Data Breaches Scheme, or NDB scheme. And something which doesn't get a lot of attention is APP 11, and we'll talk about that today, which requires entities to take reasonable steps to protect the personal information, which includes TFN information that they hold. And last but not least, and this is something I do talk about from time to time, is there are specific offence provisions under the Tax Administration Act 1953, and I'll refer to those as the TAA 1953. Just a couple of comments. It's important to note that the TPB, as a board, we are not responsible for the administration of any specific legislation relating to the use and disclosure of TFNs. The Australian Information Commissioner and the Commissioner of Taxation are the primary agencies, if you'd like to term that, responsible for the administration of these laws. However, I will make a comment about, throughout the presentation, the impact on the Code of Conduct, which is within the board's remit. With that being said, let's go over each of these in a little bit more detail. And I'm going to start with the TFN rule. And what does that actually mean for all of us on the call today? So hopefully we've got a better understanding. So the TFN rule is issued under the Privacy Act, as I spoke about earlier, and it regulates the following. And it's on the slide here. This is a really good slide that Anna's put together. We've got the collection, storage, use, disclosure, security, and also the disposal of individuals' TFN information by TFN recipients, such as, for all of you on the call today, registered tax practitioners. And when I talk about that today, that's TFAs, tax agents, and BAS agents. The rule requires that TFN information only be used or disclosed, including for matching personal information about individuals, by TFN recipients for the following reasons. So it's got to be for the purpose authorised by tax law, personal assistance law or superannuation law, or for the purpose of giving an individual any TFN information that the TFN recipient holds about that individual. Additionally, the TFN rule requires that TFN recipients take reasonable steps to protect TFN information from, amongst other things, unauthorised access, use, modification or disclosure. And that's listed on the third dot point on the slide. TFN recipients, so those of you on the call today who are registered with the board, registered practitioners, are also required to take reasonable steps to ensure that access to records containing TFN information is restricted to individuals who need to handle that information for taxation law, personal assistance law, or superannuation law, which was the first item I discussed a little bit earlier. Also, reasonable steps to securely destroy or permanently de-identify TFN information where it's no longer required by law to be retained or necessary for a purpose under the tax law, personal assistance law, or superannuation law, including the administration of such laws. Also, last but not least, you need to ensure that all staff are aware of the need to protect individuals' privacy when handling TFN information. And I'd like to emphasise that I think it's very important in larger practices that people are absolutely aware of that. Let's go on to the next slide, which is the Notifiable Data Breaches Scheme, or as I've spoken about, the NDB scheme. And it also exists under the Privacy Act. The NDB scheme effectively mandates a reporting and notification process, so two aspects there, for eligible data breaches, which are likely to result in serious harm to individuals whose personal information is involved. So very important, and that's on the second dot point on the slide there too for you. TFN recipients are also covered by the NDB scheme insofar as any eligible data breach involves TFN information. So there's a pretty clear link there. I hosted a webinar last month for those of you that did attend that with the Office of the Australian Information Commissioner, and that did go into a lot more detail about the NDB scheme. And if you're looking for more detail, and it might be worthwhile sending out a link to that webinar for those participants. And for those of you who didn't attend it, it was really worthwhile. It gave a really good in-depth understanding into the Notifiable Data Breaches scheme. Let's go on to the third aspect from the frameworks that I've been talking about here from a legislative perspective. And the next one I spoke about in the intro was the Australian Privacy Principles. And in particular, let's move and have a look at APP 11. It's as defined in the Privacy Act, individuals' TFN information is also personal information. So that's the starting principle. This means that any registered practitioner who is subject to the APPs under the Privacy Act must also generally comply with requirements under APP 11.1, which requires essentially people on the call today to take reasonable steps to protect the information from misuse, interference and loss, and unauthorised access, modification or disclosure. According to the OAIC, an interference includes an attack on a computer system that leads to the exposure of personal information. So I'd just like to highlight that. Unauthorised access also does include any access by someone who is not permitted to do so. On the other hand, unauthorised disclosure only occurs when an entity makes personal information accessible or visible to others outside the entity and releases that information from its effective control. So, for example, sending an email containing TFN information to the wrong recipient would likely constitute an unauthorised disclosure. So that's a very simple example within this principle. APP 11.2 provides that those subject to the APPs who also hold personal information of an individual must take reasonable steps to destroy or de-identify the personal information they hold once it is no longer needed for any purpose for which it may be used or disclosed under the APPs. Again, that's, to be honest, I would have thought even in the absence of that APP, that's something that's very important for practices to do in any event, just from a practical perspective. The OAIC has published several pieces of guidance on what action could be taken to comply with the obligations under the APPs I've just spoken about, and also the TFN rules. So would highly recommend that if you're looking for greater depth around this and clarity, go and search for those two pieces of guidance around those APPs and the TFN rule. The guidance also covers recommended steps to safeguard TFN information from unauthorised loss, use, disclosure, and whether this information is recorded in physical or electronic form, such as email. So I think that's going to be very helpful for all of us. These steps include appropriate security measures and particularly suggested procedures to manage email communications of TFNs and to improve the security of TFN information contained in emails, as emails is in itself not be considered to be a secure form of communication. And I'd just like to emphasise that aspect. Again, I'm going to add to your workload here, Anna. If we could send out the guidance material regarding, with reference to the relevant APPs and TFN rule, I think that will be really helpful for the participants today. Last but not least is the Tax Admin Act in terms of the frameworks I've just been talking about from a statutory perspective. Again, the TAA 1953, and as I note, it's administered by the Commissioner of Taxation, not the Tax Practitioners Board. It includes specific offence provisions in relation to the unauthorised recording, maintaining a record of, use or disclosure of a person's TFN, subject to some exceptions. The TAA 1953 has provisions that protect the TFNs of all entities, including individuals and other entities such as corporations, partnerships, super funds and trusts. So I've looked at the frameworks from a statutory perspective. Let's get into really the next section, which is your obligations for all of us on the call today. What does this mean for us? So let's look at your obligations when using or disclosing TFNs and TFN information. The board, being the TPB, expects all registered tax practitioners to consider the relevant legislation and guidance, and in particular the TFN rule, when including TFNs or TFN information on clients in email communications. That's the starting point. You must also consider whether such a record or disclosure is appropriate and secure in the circumstances, noting that there is a risk of inadvertent disclosure to third parties when communicating over emails. For example, there is a risk of emails being intercepted by third parties. It wouldn't be a webinar, I would have to say, for any of you that have listened to our webinars where we don't take parts of the code of conduct and relate it to something that is important to practitioners. And in this aspect, code item 6 is the relevant item of the code that has particular importance to the topic that we're talking about today. So the steps that you need to comply with the relevant legislation is a really good starting point in helping you assist in ensuring that you meet your ongoing compliance obligations with the Code of Professional Conduct under the Tax Agent Services Act, in particular, Code Item 6. Again, I just always like to highlight that from the time you become registered with the board, you are required to comply with the obligations under the code on an ongoing basis. It doesn't stop and start at the date of registration. Code Item 6, as I've just mentioned, is the one that's of particular importance here today, and that requires you as a registered practitioner, tax practitioner, to maintain client confidentiality, and we've had a number of webinars on this topic. You must not disclose under Code Item 6 any information relating to a client's affairs to a third party unless you have either obtained the client's permission or there is a legal duty to do so. So there's two exceptions. And just to give a bit of background, information in the context of the code refers to the acquiring or deriving of knowledge and includes, but is not limited to, capturing information known about a client. This information could be acquired directly or indirectly from the client or other sources. Importantly, when we talk about information relating to a client's affairs, it is only necessary that the information relates to the affairs of a client. So it's quite broad. Information does not have to belong to the client or have been directly provided by the client to the registered practitioner. I'd like to emphasise that. I know when I talk to a number of practitioners, they potentially have a narrower definition in this context. Additionally, for the purposes of Code Item 6 and the TASA, a third party means any other entity other than the client and the registered practitioner. That's quite precise. In relation to a registered practitioner that outsources a component of their services to another entity, i.e., for example, another registered practitioner, or you ask a legal practitioner, or you engage a contractor, either overseas or locally, the third party would include that other entity. So disclosure to a third party would also include disclosure of information relating to an entity within, let's say, a service trust structure to another entity within the same service trust structure. So you need to be very clear around when you issue an engagement letter, who is the entity providing the service. That could be an entity that is different from the party that actually may be actually undertaking the services. So you need to be very careful in that aspect. Further, a third party may also include entities that maintain off-site data storage systems, i.e. cloud storage. And we've discussed that a number of times in a number of webinars, but I just wanted to highlight that today, given the digital world that we live within. And most of the discussion today we're talking about is the use of TFNs and disclosure. A lot of our examples are via email. One of the things I just touched on earlier was engagement letters, and just to highlight there, they're not mandatory, but the board highly recommends their use in that regard. And I think today's discussion will highlight again the importance of having an engagement letter. Engagement letters, from the board's perspective, help minimise the risk of breaching Code Item 6 in circumstances involving a disclosure of a client's TFN information by email without the client's permission. And in this regard, we strongly recommend that you seek specific authority prior from the client before any disclosure is made. So use the engagement letter to actually seek their confirmation regarding the disclosure. So I think that's a really simple and succinct way to do it. And you can, for all of you, you can do electronic engagement letters, and that will also work too. If you need a little bit more information about how to put together an engagement letter, because we do get asked that question from time to time, I'm going to ask Anna again, your to-do list is getting longer, Anna, to send out some information around what we do recommend are some of the things that you should consider in putting together an engagement letter. However, with that being said, in terms of engagement letters, please note that obtaining a client's permission does not override the broader privacy and security obligations of the TFN rule and APP 11 that I just spoke about. So you can't use the engagement letter to contract out of your obligations under the TFN rule and APP 11. So in this context, you really need to make sure that you take reasonable steps to protect TFN information when it's sent via an email, even though you may have prior approval using an engagement letter. And I'll discuss these reasonable steps in the following pages in the webinar. We also expect from the board's perspective that you'll have appropriate arrangements in place to prevent inadvertent disclosure of a client's TFN and information to third parties. That's also an important point to note. Let's follow into the TFN rule and some of the guidance from the OAIC, which I did mention a little bit earlier. The board strongly recommends that you have regard to the requirements under the TFN rule, and I've spoken a bit about that already, in addition to your obligations under the Tax Administration Act 1953, when both recording and disclosing all client TFNs in email communications. This is not only a matter of best practice, but it also helps to minimise the risk of any unauthorised access or disclosure of a client's TFN, whether that be an individual or other entity client. Whether a communication of a client's TFN in an email breaches the relevant legislation is going to, in reality, depend upon the individual facts and circumstances of the inadvertent disclosure. This includes whether you've taken reasonable steps to protect the information and communication technology controls are in place that are providing adequate protection to protect the security of the TFN. According to the OAIC's guidance, what steps are reasonable in any given case ultimately depends on the circumstances of the registered practitioner, which could include the following. Again, this is not an exhaustive list, but Anna's put it up on the slide, and that's fantastic, Anna, but I'll just go through each of them individually. So, which can include the nature of the registered tax practitioner entity, the amount and sensitivity of the personal information held by the registered practitioner. So, for example, if you hold TFN information relating to a significant number of clients, you should adopt more rigorous and reliable security measures to safeguard electronically secured and communicated information. You can also include the possible adverse consequences for an individual in the case of a breach in relation to any resulting loss or misuse of TFN information. These consequences can include the risk of identity theft, and that's becoming very, very important, as we're all aware of in the world we live within. We can also have matters which can include the practical implications, such as time and cost involved in implementing the security measure. And last but not least, whether the security measure itself is privacy invasive. This means that including a client's TFN in an email does not on its own and without further information necessarily give rise to a breach of the law relating to the use and disclosure of TFNs. However, if such communication occurs in circumstances where you haven't taken reasonable steps and strategies to safeguard the information, the registered practitioner may have breached the obligations under the Privacy Act and the TFN rule. In this regard, the board recommends that you review your current practices, procedures and systems in relation to the use and disclosure of TFNs and TFN information in all email communications to ensure you comply with their obligations under the relevant legislation that I've just spoken about. Some of you are probably thinking, that's really good, Greg, you've spoken about a lot of things, but can we get into some practical steps to consider? And that's what we're going to get into now, and I think this is very important. Let's look at some things that we can be doing within our practices on a go-forward basis. So there are a number of steps that you can take to protect the security of electronically held TFNs and to ensure compliance with the relevant legislation that I've spoken about, in particular the Privacy Act and the TFN rule. Consistent with the guidance published on the OAIC website, the board considers the following non-exhaustive list are reasonable steps for registered practitioners to adopt. So I'll go through each of these in turn. Implementing security measures to restrict access to records containing this information to only those staff who need to handle this information under either the tax, personal assistance or superannuation law. Other matters or reasonable steps are having governance, culture and training frameworks in place to foster staff awareness of privacy and security. For example, maintaining authority and accountability for decisions relating to personal information security, and providing staff training on physical and information and communications, ICT in short, security and information handling. Some other reasonable steps could include encryption of systems, devices and communications that record TFN information. You may have two-factor authentication, just thinking as an example from a practical perspective. Other reasonable steps could include having policies, procedures and resources in place to determine whether TFN information held by a registered practitioner needs to be destroyed or de-identified. So having some mechanisms in place to identify when information needs to be destroyed or de-identified. Last but not least, some other reasonable steps can include taking relevant ICT security measures to protect practice hardware and software from loss or unauthorised access, use or disclosure. So for example, regular software and application tests, maintaining current versions of software and applications and effectively secure software across all of your relevant network components. Maintaining network intrusion prevention and detection systems, some people call those firewalls, that's what I would term them, and procedures to manage email communications of TFN information. So hopefully there's some practical tips for you to be thinking about and what it means for your practice going forward. Let's go on to protecting TFNs and email communications, because I've spoken a bit about that today, and I think it's important we get into a little bit more detail. We also suggest from the board's perspective that you consider the following, and again, it's a non-exhaustive list of ICT security measures and procedures to help you protect the security of TFNs in email. So here are some of the things that we suggest that you should consider. Using more secure methods than email to communicate this information. So you might have a secure website, an online mailbox, or a secure messaging where appropriate and available that potentially clients or other people can log into. You have steps regarding validating the email address with a recipient before sending any unencrypted email to them to minimise the risk of unauthorised disclosure to a person who was not the intended recipient. Another suggested step could be only sending information by email as encrypted or password protected in the attachment. Another step could be using software which redacts TFNs and TFN information within documents. And finally, last but not least, maintaining records of emails sent and received. And I would say that's very important. And that's probably led us into the next one, which is a good segue, is protecting client records. The board recommends that you have the following ICT controls in place to protect the security and confidentiality of client records and minimise the risk of a cyber attack. Again, the list I've got here, it's not exhaustive, but it's a really good starting point for you to consider. So what are some of these controls? So first, installing and maintaining antivirus software on workplace computers. Secondly, deploying firewalls on workplace computers and or workplace networks. Thirdly, ensuring the computer operating systems and programs always have the latest security patches and that they're updated. Fourthly, protecting client records or files using encryption where possible. Fifthly, regularly changing passwords, and I think we're all subject to that from a lot of our the software that we use. And last but not least, using, wherever possible, a second form of authentication to protect online accounts, for example, email. You may have two-factor authentication where you put your password into your laptop, but then you have to go to an app on your telephone, for example. We recently presented a webinar on cybersecurity and protecting your practice. And again, I'm going to add to Anna's workload. Anna, I think it'd be really worthwhile if we send out a link today for participants who didn't attend that session. Some of you are probably thinking, as we've been talking, there's quite a bit of material that we have covered from a legislative framework, and I wouldn't deny that that's the case. And as I've mentioned, what I've been talking about today, I haven't been trying to provide exhaustive lists, but things that are practical for the purposes of the webinar in that regard. It's important for me, from the board's perspective, to emphasise that each of you need to exercise your professional judgment when considering what steps to take in your particular circumstances. Each of your circumstances, each of your practices and your client bases are all uniquely different. Importantly, you can, where appropriate, go out and seek independent advice from a ICT security provider about what type of controls are appropriate for your business and your risk levels within your practice. I'd also encourage you to contact the ATO and or the OAIC or refer to the information published on their websites for any further guidance on the obligations under either the Privacy Act or the Tax Administration Act 1953, in particular with regarding the use and disclosure of TFNs and TFN information in emails. In this regard, the ATO's website is ato.gov.au, which most of you will be aware of. And the OAIC website, for those of you, it's up there, and it's got it on the slide, which is excellent, is oaic.gov.au. And again, Anna, at the end of the webinar, will be directing you through to a number of those sources at the end of today's webinar. Again, one of the things we like to do in webinars is just to highlight the importance of complying with the code and, again, what are the consequences for failing to comply. So I'm just going to go through those just briefly and then discuss some other matters. It's important that where a practitioner fails to take reasonable steps to protect TFNs and or TFN information of clients, there may be implications in relation to the TASA, in particular Code Item 6, client confidentiality. And I think client confidentiality is really, really important. It does cover large parts of our practice and activities that we undertake on a day-to-day basis. So let's have a look at some of the sanctions from the board's perspective. So we're following an investigation. If the board decides to undertake an investigation, we find a tax practitioner has failed to comply with the code, we may impose one or more of the following administrative sanctions: a written caution, an order requiring you to do certain things such as completing a course of education or training we specify, only providing certain services, providing services only under supervision. We can impose a period of suspension of registration. And last but not least, we can terminate a registration where the circumstances dictate. It's important for everybody on the call today to understand that the severity of a sanction imposed by the board will depend upon the nature and extent of the breach and the individual circumstances of each case. Therefore, I'd like to just note, if we impose an administrative sanction, where it's applicable, we will notify and give reasons to both the ATO, ASIC, where it's appropriate, and any professional association that the tax practitioner is a member of. And I think that's important just to highlight. I've got an example which I think is probably quite useful to go through, and I would hope and trust it's going to be a fairly common example that might tease out a few issues for you listening today. So let's go to the example, and it's going to deal with code item 6. So in this example, we have Olivia, registered tax agent with the board. Olivia receives an ethical letter from another registered tax agent, Matthew, about her client, Adam. Matthew informs her that he is being engaged by Adam to provide tax agent services going forward, and that he requests copies of the client's documents to make the transition as smooth as possible. This is a pretty common occurrence for all of you on the call today. Before providing Adam's documents to the new tax agent, Olivia contacts Adam and seeks his prior written permission to disclose this information to Matthew. And that written permission, just to note, can be via an email. It doesn't have to be via a letter. Importantly, Olivia informs Adam of the entity that will receive and have access to the information, and provides him an outline of the information to be disclosed, which will also include TFN and TFN information, and outlines the use of an email to disclose the information. So Adam's fully aware, and we've also received Adam's permission prior to making the disclosure. In addition to obtaining Adam's permission, Olivia takes reasonable steps to safeguard the client's TFN information by adopting various security measures in her practice to protect electronically held TFN and TFN information to minimise the risk of inadvertent disclosure. Olivia also validates Matthew's email address prior to disclosure. That's important to note. She uses a secure password-protected website to upload Adam's documents, which is linked in the email sent to Matthew. So she's using a number of different steps here to safeguard the material. Olivia also maintains a record of the emails sent and received regarding this disclosure. And I think that's a really, really good example, which most of us today will have throughout any of our times in our practice come across in that regard. I've been doing quite a bit of talking. I know there's been quite a lot of questions coming through, so I'm not sure, Fiona or Anna, I think it might be Fiona, you might be able to give me a sense of some of the questions, please.
Thanks, Greg. Yes, we've had a lot of questions today, and I'll take you through a couple of them pending time. So the first one, you mentioned that the notifiable data breaches scheme effectively mandates a reporting and notification process, which applies to eligible data breaches. So could you provide us with some examples of an eligible data breach?
Not a problem. Some of the examples, look, and again, this is not exhaustive, can include data or records containing a client or customer's personal information. It's either lost or stolen, a very simple example. Another one could be a database containing personal information is hacked. Another one could be a cyber attack results in personal information being inadvertently disclosed. And then the other one you've got is personal information is mistakenly provided to a wrong person in that regard. In this context, I'd probably recommend that people go and look at the Notifiable Data Breaches Scheme, or getting advice from the OAIC if they're concerned that there may have been an eligible data breach. Back to you, Fiona.
Thanks, Greg, for taking us through that. The next question is in regards to our code item 6. So in the webinar, you talked about how practitioners cannot disclose client information to a third party unless they have their client's permission or there's a legal duty to do so. So does that mean a tax practitioner cannot disclose information to another registered tax practitioner they work with who is not part of the same practice?
Good question. A third party, in short, is anyone other than the client and you. So in your example, another practitioner within the practice could well be a third party, or will most likely be a third party in that, depending upon the engagement letter. So in that regard, you must not disclose any information relating to the client's affairs to the third party. Let's say it's the other practitioner, even if the third party is, someone who's connected and quite close in that regard. So you will need to seek their permission before doing so.
Thanks,
Back to you,
Greg.
Fiona. Sorry.
Yeah, thanks. That's all right. The next question is related to the previous one about the third party principle. So when it comes to code item 6, would a third party also include a family member of the client, for example, the spouse of the client?
Yeah, look, again, in short, yes, a third party is anyone other than you and the client. So in this regard, a third party will be the client's spouse. So again, you will need to get the permission from the client before you can actually make the disclosure. So unfortunately, it's very strict. Back to you.
Thanks, Greg. And the next question, again, about code item 6. So you spoke about how tax practitioners can disclose client information to a third party where there is a legal obligation to do so. Could you please provide us with some examples of a legal obligation?
Yeah, sure. Look, again, it's not exhaustive, but the first one could be information that needs to be provided to the board under a notice issued pursuant to section 60-100, which is part of our information requesting powers. The other one could be information requested by a court or tribunal pursuant to a direction order or any other type of court order process, requesting that information. One which is becoming more prevalent now is information requested from AUSTRAC in accordance with reporting obligations under the Anti-Money Laundering and Counter-Terrorism Financing Act. I think it's 2006 from memory. And then the other one, which is last but not least, is information or documents that need to be provided to the ATO under a notice pursuant to section 353.10 in Schedule 1 of the Tax Admin Act concerning taxation laws. And again, this requirement is subject to that material being properly withheld by the registered agent under legal professional privilege. Important, I'd just like to note, even though you have a legal duty to disclose, you should still comply with your broader privacy obligations, as I've mentioned, by taking reasonable steps to protect the TFN information sent via email. Back to you.
Great, thanks, Greg. And I think we have time for one more question. So this one's about our letters of engagement. So what information should be included in a letter of engagement?
Very good question. Again, I'll make some overarching comments. It will be highly dependent upon the nature and services of the work to be provided and the nature of the client and the practice that you're dealing with. However, these points I'm going to articulate, I think, should be in virtually every engagement letter. So at a high level, you should be describing what is going to be done. So what's the work? Who's going to do it? Is it going to be myself? Whereas Fiona, you picked up with some questions. Is it going to be another practitioner or maybe a separate part of the practice, a different service entity? So they could be a third party. It could also be outsourced. And again, that then goes into how it will be done. And then also when and where the work is to be done. And that's very important. And then again, last but not least, how much is the work going to cost? Clients do like to know what they're going to be up for, and hopefully that avoids potential fee disputes. And also, I think it's important that depending upon the work, you should also include relevant and, if necessary, permissions, as I've touched on a little bit today, where you need to outsource to third parties and getting the relevant disclosures made in the engagement letter and getting the client to confirm those so you are compliant. I think the other thing which does get missed from time to time is an engagement letter, I think, should also include the client's responsibilities back to the practitioner to make sure that all the relevant information is available to the practitioner so that the client understands that the advice or the preparation of returns is dependent upon full and true disclosure of information. Also, I think the other thing the engagement letter can also include is the confidential nature of communications, that you will not disclose information relating to a client's affairs to a third party without their permission. I think it's just good to highlight that to them. Also, it's good for you to highlight that you have a duty as a practitioner under the TASA to act lawfully in the best interests of the client and to act with honesty and integrity. And that's to highlight to a client that a client may instruct you to do something, but where it's not lawful to do so, you cannot follow through on those instructions, or you should not be following through on those instructions. Also, the other thing it could cover off is that you should have adequate arrangements for the management of conflicts of interest. And also, last but not least, and I said this a bit sitting on the board conduct committee, is when you receive tax refunds from your client, how are you going to deal with that? And be extremely upfront with your client that if you're going to deduct, how much of the fee are you going to deduct, and when are you actually going to forward the net refund onto the client. The other bit, which I think you should also do, which goes without saying, is put your registration number with a symbol on there. It's a great way for someone to recognise that they're dealing with someone who's registered with the board. And that's something that we really like to see being done all the time by practitioners. A little bit of a lengthy response, but it's an important one for all of us today. Back to you, Fiona.
Thanks, Greg, for taking us through those questions. I think that's all we've got time for, so I'll hand back to you.
Thank you very much. Can I just say thank you to Fiona and to Julie and to Anna today. Today's session doesn't happen without all of the people here. So we highly support all of the people on here today and thank them for their work. Again, where you're not sure where to go to, we've got some good material up there. Go to the website, tpb.gov.au. If you'd like to speak to a real person, we're open 9 a.m. to 5 p.m. on the 1300 number. Again, those of you who aren't subscribing to our TPB e-news, please subscribe to it. It's a really simple way to keep up to date with what's going on at the board. And in particular, you can get important messages from the board that will be very relevant for your practice. And also, for those of you who want to keep up with your CPE, CPD, go into our YouTube channel. We've got a lot of material on there for your viewing. We understand that people may be busy during the day to listen to webinars real time, but we do have recordings of them as such. And can I just thank everybody for joining? We've had a great number of participants today, and hopefully you'll all stay safe, and we'll hopefully get you back on the next webinar. Back to you, Anna.
Thanks, Greg. Thank you for providing all that useful information, and thank you also to Fiona and Julie for answering questions through the chat box today. Thank you also to everyone in the audience for joining us. We hope you found this webinar beneficial. It's a great way for you to keep up to date with us, and as we've said, it can count towards your CPE. Remember though, we don't issue attendance certificates. If you're interested in attending more of our webinars, go to tpb.gov.au/webinars. And just before we finish up, I'll be launching an exit survey. We'd appreciate it if you could take the time to complete this survey, as it only takes a moment, and your feedback will help us to improve our webinars and lets us know of any topics that are of interest to you. The survey will open in your browser once you leave the webinar today. Once again, thank you all for joining us, and we hope you enjoy the rest of your day.